The next page will show that it is 100% owner of both Waldo and Dallas Crown Inc. USA. They are all them. This is, arm's length is not how we're doing business here. It's all the same people, same names, and same businesses. It's just all under one umbrella. I will now show you a copy of the United States District Court lawsuit brought by Beltex Corporation and Dallas Crown in the United States Federal District Court, Northern District of Texas, to stop the enforcement of the Texas Agriculture Code in regard to a prohibition for slaughter of horses for human consumption. Ms. B. Twain?
Yes, sir.
Copies for everyone there. That document is important only to the extent of some of the allegations set forth by Dallas Crown. As the board will see, from the highlighted portion, they say that the plaintiff makes no sales of horse meat for human consumption in the United States. That means that no matter what figures you see here, they're figures that are done for accounting purposes and don't really reflect what goes on with the relationship of Waldo, Dallas Crown, and Tobacco. All the sales take place in Europe. In 2000, 10,061 metric tons of processed horse meat were exported from the U.S. by two, at the time of this lawsuit, there were two horse slaughter plants in the United States. They were both in Texas, Dallas Crown and Beltex. The two plants, and again I quote from the pleadings, have processed approximately 50,000 horses per year for foreign sales. The foreign sales being made are by Tobacco, the parent company. Next we have the petition of Beltex, Cabell International, and Dallas Crown to the United States Department of Agriculture, requesting that they be allowed to pay privately for meat inspection. And I know the board's aware of the issues that have arisen over the non-funding for meat inspection by tax dollars, so now they're trying to get private funding for that. Again, this document is important only to the extent that the allegations in there are those of the meat packers, or the slaughterhouses, and from that, they allege they are the largest air freight customer at DFW International Airport, spending some $6 million annually. Their combined overhead is $27 million annually. So, starving they're not, but from their own numbers it would seem that they're not making all that much money, and there's a reason for that. The next document is a white paper produced at the request or underwritten by the estate of Paul Mellon, who was deceased, that was undertaken by two writers and paid for by the Mellon estate. Copies for each of you. These are copies of only the relevant pages for the reason that this particular report is over 50 pages in length. Most of it has nothing to do with what the board needs to consider. The white paper was underwritten by Paul Mellon, and before anybody raises the issue, Mr. Mellon is certainly not an animal activist or was not an animal activist or animal rights person. He and his family were founding members of the Jockey Club and the Thoroughbred Association of America. They funded many equine research projects. They're definitely horse people, not animal rights people. The Mellon estate and Mr. Mellon during his lifetime donated billions of dollars to institutions such as museums. They gave the initial funding to the National Gallery of Art in Washington, D.C., over $90 million to Young University, and further money to University of Virginia and historical organizations. The reporters who prepared this white paper were Stephen Kendall, who was a Foreign Service Officer at the U.S. Department of State, and for 25 years was with Newsweek, Financial World, and Forbes magazines, and was a former managing editor of Money magazine. Mr. Raymond Goyden, the other writer, was a staff at Forbes magazine and is also on the staff of McGraw-Hill Publishing Company. These people are financial writers, and they know how to do what they have been doing. So I would ask you to look at the highlighted portions of the paper. And section starts on what you will show as your second page, but it's actually page number 26 or 7, I believe. 27. Chivatico is a meat trader, wholesaler, and distributor. Now here's where it becomes important as to who's playing with who here and why and how they're doing it. When these companies purchased controlling interests in America horse slaughterhouses, including Dallas Crown, that's Chivatico, they were simply engaging in vertical integration. Now I don't even pretend to understand what that means. It takes an accountant, I suppose, for that, but they explain it. A business strategy that allows a company greater control over its sources, supplies, and raw materials. For Multi-Meat and Chivatico, owning an American slaughterhouse means that neither has to bid against other European horse meat importers. They, in essence, buy from themselves. Vertical integration also allows a marginal independent business, those consistently operating at or below break-even, to continue operating. How so? Vertical integrated firms can use profits earned at one stage in the supply chain to offset losses incurred in another. In other words, Multi-Meat and Chivatico can operate at American slaughterhouses at break-even or worse for extended periods of time, so long as the profits they earn from their meat wholesale and distributions operations back home in Europe are ample enough to guarantee their overall profitability. And as you will recall, I pointed out that this is a highly profitable business in Europe. Chivatico makes a lot of money. And it very simply does it through creative accounting. It's not, Chivatico doesn't intend for Dallas Crown to make money. It intends for Dallas Crown to be a supply for Chivatico to make money. So they can amortize anything they want with either Waldo, which they own 100% of, or Chivatico over 50 years, and it really doesn't make any difference because it's never supposed to be a good running business. It's supposed to just keep going and provide horse meat. It's not supposed to show a profit. What has become clear is that the whole idea is that for tax purposes, I would assume, because of the American tax structure, they don't want it to make a lot of money. They don't want it to own anything. Well, if they, assuming they did an arm's length transaction from Waldo to the previous one to Waldo and then Waldo on, they didn't give Dallas Crown any of it. Why? Because Chivatico doesn't need Dallas Crown to own anything. Chivatico doesn't need it to depreciate anything. Chivatico doesn't need to do anything but slaughter horses to send the meat into Europe. And it does that in large quantities. So it's making Chivatico a ton of money. So the picture that you see with the accounting records they produce, or ones that have not produced, are simply the way they want it to look on paper. And that's nothing crooked or anything. It's creative accounting. It's a good business. Because the interest here is not in making Chivatico a running big operation that makes a ton of money. The interest is in making, Dallas Crown, the interest is in making Chivatico a big operation with a ton of money. And they've done that. So whatever picture that Dallas Crown comes forward with from this point on, or for that matter, Waldo from this point on, is simply one of a creation of Chivatico. It is not one of its own freestanding corporate structure like you or I would try to want to make money for our own personal businesses. They're not supposed to. It would be counterproductive, as a matter of fact, for Chivatico's purposes, for Dallas Crown or Waldo to make a lot of money. But I would return to my point, which is, it seems as though, based on our testimony tonight, that Chivatico has everything tied up with Waldo Inc. Waldo Inc. isn't being ordered to shut down slaughterhouse operations. The operating business is being ordered to shut down, and that's Dallas Crown. So when this board, and by the way, I would also point out to the board, as I'm sure the council will, the considerations brought up by the Horse Slaughters Council about what you are to consider in your development of guidelines. It says any return on investment since inception of the use, including net income and depreciation. Even if you give Dallas Crown credit for something, and based on the evidence that the county's come up with, it really shouldn't have any credit one way or the other because it didn't own it. But even if you say, okay, it's all really one big happy family, it's already depreciated down to zero. So you have considered that. You have done what you're supposed to do, but more importantly, there's nothing in this ordinance or in Texas local government code or any of the case law that says you're bound by a thing. I mean, otherwise people just bring up documents and show there's no way in the world you can shut them down for another 15 years if you consider these factors. This board has all the duty in the world and all the right in the world to use some common sense and say, wait a minute, that's a creative accounting method, understandable, it's reasonably done, but that does not give us a real picture on what it is Waldo, Dallas Crown, and Chivatico are actually doing. If you wanted some true records on how it's working, you'd have to get Chivatico's tax records and accounting financial reports, and I can almost assure you that ain't going to happen. They're over there for a reason. They're not doing business. You don't have an office for Chivatico sitting over here. So that would be the only true picture. You're getting the picture of Chivatico once you hit, and the board is more than in its right to consider what it knows to be true picture of the value of the property and the depreciation thereof. But you've been given that tonight, and it all looks like it reads zero to me, no matter which pocket they want to say it comes out of. Because if I'm Chivatico, this is Dallas Crown, and this is Waldo, and I own both of them. It's all the same folks. And I would ask them, based on this evidence tonight, no matter what is presented, Dallas Crown doesn't own anything. Shut them down. Thank you.
Mark,
Yes, sir.
you were saying a while ago, and I just want you to forgive me, but
Yes, sir.
you were saying that you represent Dallas Crown Packing?
No, sir. Dallas Crown Incorporated.
Okay, all right, that's what I want to clarify. Thank you.
Please, the board, my name is Bruce Monty, it's M-O-N-N-I-N-G. I'm a lawyer. I'm here tonight on behalf of Waldo, and I'm going to represent to you that you're going to not have any problem getting the records you need from Waldo. I would ask, though, that they be done, that Mr. Carter and council and the board abide by the norm, by what I believe is customary in the route and when tax returns are produced, and just retain the records. Don't make extra copies you don't need, and provide them to those people only on a need-to-know basis. This is important business information that does not need to be abused. You're not going to have any problem getting the records you need from Waldo.
Just for the record, did you give the address of your office?
1901 North Acker, Dallas, Texas.
Thank you.
You say no problem, what time element are we looking at?
As I understand it, what he wants is about 10 years of tax returns.
Can that be done in 30 days, Mr. Clay, you
Sure.
were talking about?
I would be very surprised if it can't be done. Well, I think he needs it before 30 days. You're going to recess the hearing for
Right.
30 days. I would represent we would try to get them there in 2 weeks. But with the understanding, and I've asked Mr. Carter to confirm this on the record, that he will not distribute or make copies of any of the documents that are supplied other than on a need-to-know basis.
Council, I spent 30 years with Internal Revenue Service, I know how to write that
Okay,
return.
good. That's the concern we have, and I don't think there's anything unusual about that.
Mr. Moore, how long have you known that we were considering the Dallas County property to shut down?
Since I read about it in the papers a long time ago.
Okay, and how long have you been employed by Waldo Incorporated?
4 hours.
Anyone else?
Mr. Chairman, I have one issue that I want to bring up. I've got, and I don't mean to want to violate anyone's confidentiality, the documents that Mr. Carter referred to as far as tax return and schedules and financial information, Dallas Crown that he has reviewed, I have them. I can mark them as one exhibit and have copies of the originals returned to him, and then copies for your examination until your deliberations. I have no problem, but we'll agree at some point in time, when you make a decision one way or another, that we return these so we don't violate their confidentiality and identify them for the record at that point. So in case there's any kind of judicial appeal, we can recreate that record. Because as you know, the record that's being recorded, as well as the document evidence, it becomes the record of the board, which the affected party may want to appeal to an appropriate court, and we have to certify that record. So we have those issues, but I'll be more than happy to work through those with Mr. Monig and Mr. Clebrio, so that we don't unwittingly and unnecessarily violate their confidentiality. So I will go ahead and mark this as, I believe it's 23. And I'll represent to you, these are the documents that Mr. Carter reviewed in giving his opinions tonight.
Thank you very much, Counsel. I would just simply say I was comforted by seeing Mr. Holm here. I know Mr. Holm personally for some time. I know he's familiar with how confidential documents are being handled. And I understand your need to see the information so you can make an informed decision. And I think I know he also understands our need to preserve confidentiality. So I have no concerns. I appreciate Council's representation. I'm sure they'll all be followed.
Anyone else?
Just out of curiosity, I would ask if council disagrees with the evidence tonight that Waldo Inc. does not operate a slaughterhouse in Kaufman, Texas. Do you disagree with that?
What, the Waldo Inc. does not operate?
Does not operate.
I think the proof is pretty clear that Waldo Inc. owns the hard assets, and got an operating agreement of some type with Dallas Crown. But to pretend that there's no value there, in my judgment, is absurd. Or that the value is entirely consumed. No one really believes that.
I have nothing further, Mr. President, so we'll consider whatever motion you want to make to continue these proceedings.
Now, I understand that nobody else wants to be heard on the public hearing, but Mr. Claver's asked that we give them additional time so that they can prepare to cross-examine an expert witness.
I believe that is correct, as well as produce additional information.
Is it appropriate for us to go into executive session at this time to consult with counsel?
If you desire to, we will not discuss any evidence. You may ask me legal questions concerning your
Yeah.
proceedings. That's all.
I don't think it'll take very long, but I think we'd like to do that.
I need a motion on
It is posted on the agenda for that executive session.
It is. Well, I'd make a motion that we begin the executive session.
Second. Second, all in favor, turn aye. Opposed, no. Okay, where do we meet?
You can meet with me so that everyone doesn't have to leave. We can use, I believe, they've left the city manager's office since he's not here.
Is that all right, George?
I don't want to.
They're gonna go meet and then we'll do
And then the rest should be numbered consecutively. And so what we've done also for the benefit of Dallas Crown is we have the tax records. We will not make any more copies of that, and we will tender that for your review whenever you deem appropriate to do your deliberations. And we'll not make any extra copies of that as our custom to make copies for all of you. So there'll only be one copy of document 23 to ensure those tabs
We need to post the time for the record at the end of the executive session.
That's what's being done.
And declare that, and then consider the action as item number 1 under that executive session.
Okay, we'll go ahead and declare that the executive session is 7:56. Officially, we'll put down, and I'll hear on February the 7th, Tuesday.
Just so that, for the record, Mr. Chairman, we discussed legal matters with me, concerns that you had, and also trying to establish an appropriate time to consider selecting to continue the hearing and questions relative to continue the hearing. There was no deliberation by any member of the board on any ultimate decision in this case. And I
I want to pull the commission, is that right, Mr. Kelly? Mr. Earl?
Yes.
Ms. Jones? Mr. Reed?
Yes.
Mr.
Yes.
Thank you.
Okay, the consent agenda is what you were talking about, Terry?
No, no, you need official action of the
Oh,
executive
okay.
session is to state a time of reconvening the meeting.
Okay,
John, I'd make a motion that we continue the public hearing until March the 9th, 2006 at 6 p.m.
here a second.
Second motion.
Motion's been seconded, all in favor say aye.
Aye.
All opposed say no. Okay, we'll continue the public hearing, that will be March the 9th at 6 o'clock at this location.
Mr. Chairman, can I
Anything else before the board tonight?
Just out of
Business
curiosity,
as usual.
Terry, if we reserve, if the board's feelings and reserving the possibility more to go in executive session the next time.
I'll put that in.
Yeah.
To have that option available.
Sure, I'll do that. And then, we should need to go to consent agenda.
What's on that?
Okay. All right, the next thing we need to do is, on the zoning board of adjustment minutes from September 27th to October 25th, and November 22nd, and then November 29th, all of 2005 regular meetings.
I'll make the motion, we approve the minutes as presented to us for those 4 days.
Second motion.
Motion's been made, second's been made, all in favor say aye.
Aye.
All opposed say no. Okay, minutes have been approved. And, have we got anything else that we need to consider, not on the regular agenda?
Anyway, I'll make a motion that we adjourn.
Motion's been made, do I hear a second?
Second.
Motion second, all in favor say aye.
Aye.
All opposed say no.